Welcome to another episode of Washington in Focus. I'm your host, Tim Klausler, with the Center Square's Washington State investigative reporter, TJ Martinell, here to talk about a recent story of his where he obtained public records from the state attorney general's office, where the AGO had directed the Secretary of State's office to release attorney-client privilege documents to the Center Square in response to a separate request. TJ, what concerns does this raise around disclosure with these agencies?
I mean, it's difficult for maybe people who are not familiar with how an attorney-client relationship works, but effectively, their communication is supposed to be kept private, confidential, and even though these are public officials, elected officials using taxpayer resources, they are exempt from public disclosure. What happened is I got emails and documents, one of which was unredacted when it should have been redacted, that I reached out to the Attorney General's office for comment on, and they issued a statement to me. So they commented to me on attorney-client privileged communications. And then I received an email from the Secretary of State's office saying, we released that accidentally. We're requesting that you delete it. Well, I did. I said, actually, I'm not going to delete it. Also, you need to give me more records unredacted because your attorney commented on them and waived protection. Attorneys can't waive privilege on behalf of their client, but by commenting on them, they can't claim privilege anymore. And so the Secretary of State's office has issued a statement to me saying that they did not waive privilege. And I asked them if their attorney, the Attorney General's office, gave them permission. If the Secretary of State's office gave the Attorney General's office permission to publicly comment on these things, and they said we haven't waived privilege. So I can only imagine the conversations that were going on between the Attorney General's office and the Secretary of State's office. And so what happened is the attorneys with the AGO told the Secretary of State's office to release unredacted, release other records under my appeal as a middle ground. And that they're in this really weird spot where they're claiming privilege, but they can't claim privilege because they've released these records to me voluntarily. The Secretary of State's office said they did it in the interest of transparency. The Attorney General's office is saying, oh, it's a middle ground. Well, what does that tell you about the legal position they're in, or in regards to the Public Records Act? It means that when I appealed, I had a legitimate case. The Attorney General's office publicly commented on attorney-client privileged communications without permission from their client. And so that for people who are not familiar with the attorney-client relationship, there was a book and a movie that came out called The Firm, which is about a young lawyer who works at a law firm that's ultimately their client is the mob, is the organized crime. And he's trying to get out of that situation. And much of the plot revolves around him trying to do so without violating attorney-client privilege, right? Even though they're the mob, they've got, he has an obligation to represent his clients. And so he can't come out. I understand it's not a fully accurate plot in terms of how attorney-client relationships work. But the whole point is that even if your client is committing crimes, you can't reveal certain things. And so that goes to reflect on the fact that the Attorney General's office didn't tell me we can't comment on these. It's attorney-client privileged. So go ahead.
I was just going to say, and for context for the listeners, all these records were in relation to the state's new income tax and potential legal challenges over the referendum process and other parts of the tax, which has been highly controversial before and after its passage. Our listeners and our readers might see your stories and say, well, thank God that they handed over these records, even though that they weren't supposed to. But at the same time, this whole back and forth with the AGO and the Secretary of State's office kind of goes to show how they're handling the income tax issue, especially their communications and maintaining the state's image around it. What is this back and forth and them coming back to you and saying, oh, no, we didn't mean to give you these records? What does this say about their general position or their approach to defending the state's image?
I think the question to ask Tim is, you know, should I mean, we can get. I think it's just a question of the attorney general's office is the top attorneys in the state, and they don't seem to understand basic. It's like that line from A Few Good Men. It's like they missed that day they taught law school. You don't talk about your client's communications with you.
So, in another round of records requests, you also received this form. I think it was from the Secretary of State's office, but correct me on this. But it's essentially this form that they send to people when they've accidentally turned over records that they're not supposed to. Can you kind of tell me about that form and whether or not this is common practice?
Well, apparently it is because the Washington Association of Public Records Officers has it on their website. It's available to download. So I got it through a public records request, but I also got the link to where it's comes from. And I actually talked to the Coalition for Open Government, and they just said they've never seen anything like it. Um, and so I just think that it's fascinating that they have this form because to be fair, it's a request. But at the same time, I don't understand the point because I get my guess is it's probably not meant to be for media or people who are like watchdogs or investigators. I think it's meant for ordinary people who file a request, get something, they get an official letter from the Secretary of State or whoever saying, "Can you please delete these?" And I get it. They're not ordering you to, which you know that would be illegal.
Do they have
So
any legal standing to claw back these records?
Well, this is the part that kind of baffles me. Let's say they said, "Oh, you legally need to turn these over." I just put them on some, I upload it to a cloud or drive and then disperse it to 50 different people. It's now out in the open. This is the year 2026, right? This isn't like 1620 or 1785 or whatever year where, you have the physical copies and copying things are really complicated and expensive and, it can be contained easily. This is the internet. The moment I get a public record to download, I can re-upload it to the internet and send it out to as many people as I want within seconds. So the whole idea that they have some sort of ability to claw back records, no, you can't in any practical sense. Because the moment, if I ever got a letter from any government agency saying, "Hey, you need to delete these records or give them back to us," or whatever it is. First of all, how do I give them back to you? It's not physical. So I just, to me, it's a courtesy letter that they send out just if in the event that something happens with it. And again, these are records that should not be released unredacted. But to get back to your other point, Tim, this really does raise questions of to what extent should attorney-client privilege between public officials using taxpayer resources be kept as confidential as if it was private practice? I think that that's a legitimate question is should we broaden the public records laws to allow for greater disclosure of communications between the attorney general's office and other public officials where they're giving them advice on stuff that concerns public policy and concerns like taxes, like the whole story did back in April, which was about them crafting a bill to trigger a lawsuit that would cause the state Supreme Court to overturn a ban on progressive income taxes in the state. So yeah, that's something that many people think the public should be able to know is that they're advising their clients to do things that affect taxpayers. So I mean, we as a result of these stories, we might see people pushing that more and more. Who knows, but it really does raise the question because some of this information is very fascinating, very revealing, and provides greater understanding of government. For example, the email with this story was from, it wasn't an email, it was a comment by Deputy Solicitor General Carl Smith. And he said two things that one, that the court might rule allowing a referendum on the new income tax to avoid dealing with the constitutional question. And this is a former state Supreme Court clerk. And so he would know them. And this is him giving his opinion of how they think and how they operate. The other one was a comment that he was quoting from Solicitor General Noah Purcell saying that the state Supreme Court is as favorable a venue as we're going to get. So again, this allows us, the public, to have an understanding of what government officials are saying that we otherwise wouldn't know if these records have been released redacted. And so that's it is better informing the public about what's going on in this way. So again, I understand how an attorney would say, "Look, I need to be able to protect my clients' communications. They need to be able to speak with me frankly." A response to that could be, "Well, great. If you're in the private sector, that's fine, but you're not. You're getting taxpayer dollars." So,
Well, TJ, appreciate your reporting on this issue and all the records requests that you file to get these disclosures from the agencies. For anyone hoping to read those stories, you can catch them at thecentersquare.com. Otherwise, thank you for joining us for another episode of Washington in Focus.